So for our next segment, we're going to be talking about corporate and business issues as they relate to somebody starting up a drone business. And so I'd like to introduce my partner, Ian McDaniel. He handles all the corporate and business and securities issues here at our law firm. And so, Ian, let me start off by just asking you, why would somebody want to consider forming a business entity?
So there are two main reasons why one might form a business entity. The first is limitation of liability. And as a sole proprietor, the business owner would be liable for all of the potential liabilities of the business, and all of that person's personal assets would be exposed to creditors, whether those
if this crashes, basically you want to be protected.
Right. So those creditors could be in tort, or they could be in contract. Okay. It could be products liability, or they could be contractual liabilities that you enter into in the course of doing business. So number one is limited liability. Number two is the ability to attract investors. So in the event that you are doing business as a sole proprietor, you don't have any interest in your company to sell.
Okay.
So forming a business entity gives you the ability to seek investment from outside sources on a basis other than simply borrowing that money from a lender.
Okay. Now, a lot of the drone clients that we're running into right now, some of them invent new things relating to drones, such as if you had a new gimbal that allowed the camera to rotate nicely, or as Dave and Doug were talking about earlier, if you had a new battery that allowed your drone to fly in the air twice as long as any other drone. A lot of our drone clients are inventing products. A lot of other drone clients, though, they're providing services such as filming for movies, for realtors, things like that. Would your advice on what kind of business entity they might want to form, or what kind of other precautions they might want to take, depend upon whether they're making a product that could crash onto somebody's cars, or whether they're providing a service where presumably they could do a poor job providing the service?
So that's an excellent question, and there isn't a distinction necessarily between the limited liability characteristics of the different entities. However, there may be tax characteristics of the different entities that would drive that decision.
Okay.
So if you are primarily going to be a service business, you're going to be, and your income is going to be from providing services, something like an S corporation may be a more natural choice, because in that scenario, I'm less concerned about going to investors for money.
Okay.
And I would like to see the client in that scenario take advantage of the tax benefits of the S election. Most startup clients, though, are going to be raising money from investors. Investors are generally hostile to S corps, so we would be thinking most commonly about a C corp or an LLC in the true startup scenario.
Now, a lot of the drone clients that I'm running into, they have questions about how many entities they should form. So, for example, with a lot of people in the drone industry and outside, the general theory is they form one company by which they run the product, or they make the product, or they sell the service, and they have another company to hold the intellectual property. What do you think of that strategy?
I think it's generally an excellent strategy, provided that investors will tolerate it. If your investors are there primarily because of the technology, they are going to insist either that the company in which they are investing owns that technology, or that there is a very strong agreement pursuant to which the entity in which they're investing is licensing the technology from the holding company. So whether that arrangement is exclusive or not is going to depend on the terms of any particular deal. However, it does permit the owners of the corporation, the founders, to protect their IP from potential claims that arise in the course of doing business under the operating company.
Okay, so that's a good point. So we run into a lot of investors who are concerned, and they want to make sure that they've got their teeth into the intellectual property, because when you're a startup, that's sometimes the only valuable thing you have to sell people. Okay, great. I'd like to talk a little bit about the common mistakes that inventors and small businesses make when they're trying to set up a company. Now, in the patent world where I practice, we have this thing called the provisional patent application that will give an inventor up to a year of patent pending status. Now, the idea is that you have a quality provisional prepared, and within a year, you file a utility patent application that claims priority back to the provisional. If the provisional is written well enough, it will what is called support the utility patent application, so you can effectively claim the priority date from your provisional. This allows you a year to go out, try to sell your invention, attract investors, do some R&D, get on Shark Tank, put it on Kickstarter, whatever you want to do to try to get attention to your product while you still are patent pending. So oftentimes we'll see a mistake at the provisional stage where we have inventors who try to draft their own provisional, or they try to do it online, and there's a whole bunch of places you can do really cheap provisional patent applications. The problem is oftentimes the provisional that results from these are pretty much garbage, and the USPTO examiner and other people have the right to question whether or not the utility patent can effectively claim priority back to the provisional. So you really want to make sure that your inventors and your small businesses have a good job done on the provisional so it won't later affect their patent rights. Now, in the corporate and securities and investment world, is there anything similar to this? Do you see anything similar to this phenomenon?
Well, certainly we see lots of clients who organize their companies via some low-cost online entity. These can have potentially disastrous consequences later on. The mistakes that we see commonly are mistakes in the organization of the company, either the wrong entity type. So an example of that would be the organization of an entity, or the governing documents of the entity are set up in a way that investors are hostile to.
Could you give me some examples of that?
Certainly, investors generally don't like to invest in S corps versus C corps. Investors are generally, without some careful craftsmanship of the operating agreement, hostile to flow-through entities. So any entity in which the profit and loss of the company flows through to the personal income tax returns of its owners. We see mistakes in the capital characteristics of the company as well. So I have seen founders who failed to leave themselves any dilutive ability, for instance, by issuing all of the shares that are authorized to either the founders themselves or the founder and a few early advisors or investors.
Now, what is the problem with that in terms of dilution? Why do you want to have shares that have not been issued yet?
Well, early stage companies frequently use small amounts of equity as a means of attracting advisors. Mm-hmm. You would need it for investors. You would need it even for employee or consultant stock option plans, so-called sweat equity.
Okay.
So in the event that all of the authorized shares in a corporation, for instance, are issued to the founder or founders and early investors, the company's ability to issue additional shares for that stock option plan, for those advisors, for those other critical early stage needs is very limited. Okay. And it gets increasingly difficult the more shareholders that you have to amend the articles of incorporation to authorize more shares and get that dilutive ability that may be critical later on. An additional problem is if there aren't shares to convert into, it can hamstring the ability of the company to issue convertible notes later on down the line. And convertible notes being a very, very common vehicle for seed rounds of investment, you really, really need to be able to issue those.
Okay, so it sounds like in the corporate and the securities and investment area, it's just like the patent area, where an initial mistake can cost you many times over what you think you saved by not hiring an attorney or a competent attorney to handle the initial rounds. Certainly,
and those problems tend to be magnified over successive rounds of investment.
Okay.
So to use convertible notes as an example, convertible notes tend to convert at a discount and occasionally or frequently have valuation caps. These features dilute the existing shareholders out of proportion to the shares that are issued in that next equity financing. So because of that property, the initial mistakes in cap table management, for lack of a better phrase, tend to be magnified. So if early stage companies give away too much equity to early investors, your friends, family, and fools, if they give away too much equity to their early advisory board members or their early employees and consultants, those problems can be, they can result in the founders losing their status as majority shareholder relatively early on.
Okay, that sounds like it could be a serious problem.
It's a serious mistake, and even simple mistakes in governance or authorizing enough shares tend to be more difficult to ameliorate down the line, because you need more permissions from more investors and shareholders.
Okay, great. That's been good information. Okay, so I know that adhering to the securities laws are very important for a startup business. At what stage should a startup start worrying about securities laws and how they may apply to the various types of people who may be investing in a business?
So really, anytime a founder accepts money from an outside investor, that needs to be either registered with the SEC and qualified with the Commissioner of the Department of Business Oversight in California, or exempted from those requirements. Most early stage companies the offerings done by most early stage companies are exempt from both registration and qualification if they're conducted properly. Certainly this is something that most investors and many lawyers are not able to do well by themselves. A common mistake made by early stage founders is to ignore securities regulation in the context of friends and family investments.
Okay.
They assume that simply because they're selling a few shares in their stock to Uncle Jim for $5,000 that the SEC couldn't possibly be interested in that. The difficulty there is that the SEC does have regulations that relate to those offerings.
Even friends, family, and fools?
Particularly if they're across state lines. The SEC is certainly interested. And the state of California, through the Department of Business Oversight, is interested no matter what.
Okay.
So it is very important that anytime someone accepts money, whether it is via debt, unless the debt is truly just a loan at a fixed rate of return that's defined in the loan instrument, any sort of debt security or equity should be offered and issued in accordance with some exemption from securities regulation and qualification.
Okay. So you drone operators who are starting a business, be careful when you're borrowing money, particularly when it's across state lines, correct?
Correct.
Okay.
Right.